in here again. We'll get the recording started and get ready to go here. So I will call the Committee of Civil Law and Data Practices to order. Today's date is Thursday, February 4, 2021. We do have a quorum present. And members, our agenda today has 3 bills on it. First, we will pick up Senate File 193 from the table. That's a Senator Benson bill. And Senator Benson, welcome back to the committee. There's one additional testifier that was not with us on Tuesday that I will have share his thoughts on this bill. The other testifiers that we did hear on Tuesday, my plan was to just have them on standby in case answers for questions were needed. But Senator Benson, I'll give you first opportunity if there's any reintroduction or updates that you'd like to make to your bill first.
Thank you, Mr. Chair. And if the bill is off the table, I will proceed. We did receive a letter from the firm that is acting on behalf of the Psychology Interjurisdictional Compact Commission, and they indicated that amendments that we had discussed would be material enough to put our entrance into the Compact at risk. That includes amending the preamble, changing the standard for employees and agents of the commission to a negligence standard, and any change of venue jurisdiction. And so, members, it is my concern, and while I respect greatly the concerns of this committee, it is my request that this committee weigh those concerns versus advancement of this bill to put us into the compact. It is my opinion that the compact benefit outweighs the risk of concerns associated with those changes. For example, removing the whereas clauses, the preamble, as it were. There is a provision in that preamble that has been used as part of an opinion. If we go to page 2.4, the states have a vested interest in the public's health and safety. That goes beyond scope, and that would allow, for example, protection of our duty to warn statute, which is important in Minnesota law, even though it is not within the scope of practice. And leaving that provision in would allow a defense against duty to warn. And so, while I agree with Senator Latz and others that the purpose articles are not something that we do in our legislature, other legislatures do them, and I would never be so dismissive as to call it legislative preference, but I would hope that the importance of this compact would outweigh that particular preference. And given that our medical compact does have a purpose article, this is not without precedent. The second, the negligence concern. In our other compacts, for example, the Interstate Compact for Adult Offender Supervision does not have a negligence standard. Let's remember that standard would only apply to the employees, the executive director, the members and officers of the commission. It doesn't apply to the commission as an entity, and it doesn't apply to the professionals that are licensed. Those are completely separate conversations from this standard, and adding a negligence standard, as I said before, would materially change this compact language and put in peril our ability to join the compact. The third concern is the jurisdictional question. I agree, for the benefit of Minnesotans, being able to have the state of harm be a jurisdictional choice is important. Again, that would be a material change that would put at risk our ability to enter into this compact. And I contend that the risk of harm in our jurisdiction is very small, because it doesn't apply to the people licensed in association with this compact. It applies to the commission itself. So the likelihood that the commission would be in Minnesota, yes, it would be an inconvenience if something happened. Perhaps some would contend that it's more than an inconvenience. But again, the risk of that exchange is small. I will not insult your intelligence by saying immaterial, but it is small. And I think the benefit of entering the compact is greater than the risk to Minnesotans. And so I would ask that this committee, after you believe sufficient debate, would vote to move this compact forward unamended.
Thank you, Senator Benson. I would like to then turn to our new testifier for today, Mr. Doug Wolfberg, the counsel for the PSYPACT Commission first, and then we can go to any questions from the committee to the chief author or any of the testifiers. Mr. Wolfberg, welcome to the committee. Please identify yourself for the record and feel free to begin.
Good morning, Senator, Mr. Chairman. Thank you. My name is Doug Wolfberg. I am a principal at the law firm of Page, Wolfberg & Worth. And our firm is under contract with the Council of State Governments. And in that capacity, I am here as counsel for the Psychology Interjurisdictional Compact, known as PSYPACT. And I do also represent other interstate compact commissions. So I have some experience beyond just this particular compact. PSYPACT, as you have heard, I'm sure, offers a leap forward to break down barriers, expand access, and to expand opportunity for practitioners. And I want to also note that this is, and the reason our firm is involved, is that the Council of State Governments has entered into an agreement with the Department of Defense under a defense bill, because it is DoD policy to expand interstate compacts across all professions and types of licenses as a benefit to military families for transitioning and moving military families. So this is a DoD priority, and that's why they entered into the agreement with CSG and why our firm was recruited to assist interstate commissions, because this is a defense priority as well. I was asked, as Senator Benson mentioned, to do a letter as PSYPACT counsel to speak about the effect of certain amendments. And the bottom line is that if the state passes PSYPACT with amendments, and nobody's here to say you can't amend the legislation because you're a sovereign state, but our role at the commission is to say that if a state does enact the compact with amendments, then a review process is going to have to occur to determine if those amendments are material and if they would disqualify the state from membership in the commission and then from becoming a PSYPACT state. I want to stress that that determination is up to the commission. I am not a duly appointed commissioner of any of the states. I am legal counsel to PSYPACT. PSYPACT would no doubt ask for my opinion, but it wouldn't be the first time a client, says thank you, to their lawyer and then acts on their own accord. So I cannot predict, and I do not represent what the commission would do with regard to any amendments that were presented to it. I can only say that if they were to ask me my opinion and then give any weight to that opinion, what that opinion would be. So I just want to be very clear about that. So the bottom line is that if Minnesota enacts PSYPACT with amendments, no assurances can be given with regard to Minnesota's admission into the commission or to become a PSYPACT member state. If it is passed without amendments, that assurance can be given. So that's really the simple choice. So again, we're not going to say no state is allowed to pass and you're allowed to do what you want, but the commission has its own process to determine if that state would be eligible or not. So with that, I just want to offer a couple of quick comments about the substance of the amendments that I've seen. And first off, to echo what Senator Benson said, I'm a former liability attorney, practicing liability attorney, and it is hard for me to conceive of a set of facts in which the right of recovery of a Minnesotan would be cut off if it didn't have that negligence standard in the PSYPACT legislation, because it's difficult to conceive of a set of facts where the PSYPACT commissioners would owe that duty or have that liability to citizen of an individual state. So I think it's an extremely remote substantive possibility. Secondly, and this is important, under the compact, it is clear that the scope of practice of the receiving state is what governs the practice into that state, whether it's telepsychology or temporary in-person practice. The meaning of that is that the PSYPACT commissioners would have no involvement in establishing the practice standards that would likely be at issue in a psychiatric malpractice case anyway. Third, and this is more as to interstate compacts, but interstate compacts are agreements between states. And one state, therefore, cannot enter that compact on terms that materially alter the bargain, that all the other states made when they enacted that compact. For instance, if a commissioner could have to answer for a case in court in a state that their state, did not consent to venue or jurisdiction in, but another state unilaterally takes that upon itself, then that alters fundamentally the bargain that the states have all made with each other. And then fourth and finally, just again to echo Senator Benson's comments, I think the important thing, and I certainly do not fault the groups that look at this and say, oh, well, anytime we see the word immunity, we want to make sure that Minnesotans have a right of recovery and we want to limit that immunity. And that's a perfectly valid interest for that particular interest group. I would say, however, that in this case, the benefit of those amendments, I think, is outweighed by the benefit of getting into PSYPACT. I don't think there's enough benefit to those amendments to justify putting those amendments in the final legislation at risk of not being admitted. And as I did emphasize in that letter that Senator Benson referred to, it would be our opinion to the commission that those amendments would be material inconsistencies with the compact. And our recommendation would be that such amendments would be disqualifying. But again, I state that is a determination for the commission. So with that, that's all I wanted to say as opening remarks. I'm happy to answer questions, and I thank you.
Thank you very much, Mr. Wolfberg. I'll open it up to the committee now for any questions to the chief author or our testifiers. Senator Bigham.
Thank you, Mr. Chair, and thank you, Senator Benson. I know that you are probably one of the most diligent members of this body, so I know this is probably stressing you out a little bit because it isn't ideally how you would want to pass a bill. So I am very empathetic to that, and I really believe in the intent of this bill. But I also believe that there are some concerns. I'm going to set aside the resolution, the preamble, whatever. You've made it crystal clear, and I'm respecting Chair Matthews, that is not our jurisdiction. So there's no reason to discuss that. But I do have some questions for the testifier. Now, most recently, the governor of Michigan has vetoed a bill to join the compact and alluded to some of the same concerns we have are in the discussions we're having today in her veto letter. And I know there are other states that probably would like to join but have concerns. Can you talk a little bit, Mr. Wolfberg, and thank you for being here today. Can you talk a little bit about how your organization has discussions regarding the concerns of some of these states? Because I'm assuming you understand that we would have strength in numbers. That's the reason we're doing the bill, so that we have access via telemedicine to services that are now insufficient for the demand that we need. So I guess what I'm wondering, what are the conversations going on at the compact about addressing some of these issues? Because, the majority party is going to have the votes to move this bill out, move it off the floor. They're going to be able to do what they want. But I have to answer to my constituents about some of these concerns when they ask about it. And so my question is, if Senator Benson's able to get this through in the House unchanged and we join your compact and Senator Benson and this committee have these concerns, what is what are the discussions going on? Is it that, I mean, a couple states that are having issues, they don't want to join the compact because of it? I mean, can you just give us a status update of how that would work?
Mr. Wolfberg.
Thank you, Mr. Chairman. Yes, I appreciate the senator's question, and I can say that I think a lot of the discussions that are going on are along the lines of what we're doing here, which is debate and education. I think, this is a dense piece of legislation, so I think a part of our role is to help to educate and provide technical assistance to states so that we can sort of describe the working. One concern, I'll just give you a quick example, is that there's concern that psychologists won't any longer be answerable to their own state regulatory bodies, and that somehow those bodies are deprived of jurisdiction. And of course, that's not the case. Those bodies are the primary entities that oversee licensees. So we help to educate that even though there's a lot of words in this bill, that the fundamental sovereignty of the state and the state scope of practice are still the controlling aspects of the practice of psychology. So technical assistance and education are a big part of that. Secondly, there are provisions to be able to amend an interstate compact. I won't tell you that they're the easiest things in the world to do, but there are provisions to amend interstate compacts. And then third and finally, we do try to point out, as you just have, that the benefits of membership in these compacts have outweighed those concerns for states that have adopted it. 15 states have adopted PSYPACT, and it's only been that commission has only been stood up for about 2 years, if that. So, and the states that have joined have just not seen those problems materialize. So there has been some comfort that other states can take in those concerns, valid as they are, simply having not materialized. So I'd cite those three things, and thank you for your question.
Follow up, Senator Bingham.
Yeah, Mr. Chair, just the one other question I have is, if there are assurances that things will be addressed that have concerns, maybe something for Senator Benson's consideration is some sort of comfort language at some point that is unrelated to the actual part of the bill that needs to have us join, but comfort language that if something isn't addressed within so many days, that we can opt out of it or some, I don't know. I'm just, again, maybe throwing some things out there because I really do believe in the intent of this bill, but I really do have concerns that have been shared by the committee. So I'll go back on mute now, but just kind of wanted to throw that stuff out there.
Thank you, Senator Bingham. Senator Benson, did you have a response?
Mr. Chair, if I could, and to Mr. Wolfberg, I know that amending compacts is not easy, but I hope that from the conversation we have here, that you will take, particularly for me, the concerns about jurisdiction and tight legislative crafting. You are in a significant role with an entity that takes a great deal of responsibility for interstate compacts. And so I will follow up from this lesson that I have learned and that I am learning, because I'd like us to be better at this going forward.
Thank you. Next, Senator Latz.
Thank you, Mr. Chairman. Appreciate the opportunity to revisit these issues that were left unresolved on Tuesday. I, for one, am not prepared, I guess, to concede that the political majority on the committee is going to ram a bill through that we aren't quite comfortable with yet. I guess I have confidence that the individual members of the committee will take our responsibilities as members of the Civil Law Committee to apply the standards and precepts and principles of civil law to determining if we want a bill to become law in the form that it's passed out of this committee, or if we think it's not quite ready yet, and not something that we're comfortable with. In my view, this bill is the responsibility of this committee to put it in the shape that the Civil Law Committee thinks should become law. And so I'm hopeful that we won't, in a sense, pass the buck on to the legislature as a whole, or even worse, in my estimation, to the very body, the Interstate Compact Commission, that we think has sent us a deficient proposition, if in fact we think it's deficient. Because I have zero confidence that any words here today of, yeah, we'll take a look at it, will have any impact whatsoever once it gets down the road and we're in the compact. We'll be one of 17 that had passed a law that adopted their language, and they're not going to have any incentive whatsoever to modify anything. The only leverage that would ever cause that kind of a rethinking would be if enough states say we're not going to join your compact without the changes that address our concerns about sovereignty and protecting our own citizens with recourse in the event that our citizens are harmed. So with that said, I do have a couple of questions. I'm glad Mr. Wolfberg is here because I'm a little bit unclear on a couple of things. First of all, is this entity considered a governmental agency, sir, or is it considered a nonprofit? What kind of animal is it?
Mr. Wolfberg.
Thank you, Mr. Chairman. That is one of the most common questions we get, and it's not the most straightforward to answer. The short answer, sir, is that it is an instrumentality of the states. So essentially, it has the characteristics of a state agency. It is not a nonprofit organization. So it is considered an interstate commission that operates as an instrumentality of the states, is the shortest answer that I can give you.
Senator Latz.
Thank you, Mr. Chairman. Mr. Wolfberg, then is the way it's set up now, does the state of Georgia law relating to governmental immunity govern and apply to this particular compact commission?
Mr. Wolfberg.
Thank you, Mr. Chairman. That's a great question. Choice of law is something we've all, and most of you have labored over in law school for weeks one day.
I resisted it mightily.
Yes. And but I can tell you that I don't recall a substantive choice of law provision as much as a choice of venue provision. So I think the question of choice of law would be something that could be briefed by the parties. For instance, if it was a straightforward case of malpractice that ended up in another jurisdiction, I don't know that there would be much question that the substantive law of the state where the act of malpractice, the act or omission occurred, would be applicable, especially since the scope of practice is what governs. So I think that's it's a very good question, but it's a complicated answer. I don't think that there is a statutory choice of law, just a statutory choice of venue.
Senator Latz.
Thank you, Mr. Chairman. Mr. Wolfberg, to follow up on that, then, let's say it's not a malpractice action, but it's an action against the commission for failing to properly flag an adverse action that's been taken against a practitioner. And as a result, a patient is harmed. If the venue is determined to be Georgia, what state's laws apply to govern the Compact Commission's liability for a claim such as that?
Mr. Wolfberg.
Thank you, Mr. Chairman. Senator, without having extensively researched that question, I wouldn't want to put any court or any commission in a bind as to my answer. I would say that the choice of law itself would be a litigated issue. If I had to express an opinion worth whatever that opinion is, I would say the law of the jurisdiction where the act or omission occurred and causing the harm to the plaintiff. That would be my academic response, but I have not had opportunity to research that question because thankfully there's been no litigation involving the commission, and I'm knocking on the desk that is made of wood.
Senator Latz.
Thank you. So, Mr. Wolfberg, so we have an unanswered question, which to me is a very significant question because it would have a dramatic impact on the ability of an aggrieved person from Minnesota to recover potentially from the commission itself. It's clearly something that is of a concern to the commission because the compact language does have proposed immunity language in there. So you would have one question of the application of the state law, and which state law, but assuming it would be Georgia because that's where the commission's principal place of business or office is located. How would that interrelate with the terms of the compact itself, which attempts to define the standards of liability for holding not only perhaps the commission responsible, but also its members, its officers, its employees, which mean all of the employees, and its executive director. So I'm a little bit confused. Maybe you can clarify for me. If you have a really hard time imagining a fact scenario under which a claim such as this could be made, then I don't see how any modification we make would be material to the compact itself. On the other hand, if there is, the fact that it's even in the compact suggests to me that there is some real concern about potential claims, and that's why it's there. So maybe you can help me understand how you would determine if this is a material provision or not.
Mr. Wolfberg.
Thank you, Mr. Chairman. That's a fantastic question. And I would say just once again that there is no substantive choice of law provision in the compact. It is merely a choice of venue. So I don't think that question I don't think that means that Georgia law is the default substantive law that would adjudicate the dispute. But your question about if there's very inconceivable fact patterns that would lead to liability on the part of the commissioners, why would we consider amendments to be material to that? And you know, that's a fair question. I would say, I would echo Senator Benson's words. I'm not going to insult the intelligence of the committee to say that there is no conceivable set of facts. I'm going to say that in my 26 years of experience as a practicing litigator and attorney, I have not seen such facts, but that doesn't, of course, mean that there couldn't be. So the other answer I would give you to that is that because an interstate compact is an agreement between the states, those states that have joined would have to all consent to that amendment or those amendments by ratifying changes to the choice of venue, because that is the bargain on which the entering states have joined the compact. So that, I grant you, that is more of a procedural question than a substantive procedural answer than a substantive answer, but it is an answer nonetheless. So thank you.
So
Senator Latz, any more follow-up?
yes, thank you, Mr. Chairman. So Mr. Wolfberg, does Georgia have the vicarious official immunity doctrine in its state law?
Mr. Wolfberg.
Senator, I don't know the answer to that question. I am not admitted to practice in the state of Georgia, and I have not had occasion to research that.
Senator Latz.
So, Mr. Chairman, that's a standard which basically applies immunities that apply to individual employees or officers, directors, members of the board of an entity. It applies that immunity standard to the entity as a whole. Minnesota actually does have that doctrine in our case law. So it makes it even more relevant that the provision in the proposed compact here that purports to provide very broad immunity to members of the commission, employees of the commission, and so on, other than intentional torts. If that doctrine exists in Georgia and Georgia ends up being the choice of law, or whatever state ends up being the choice of law, then that would insulate the commission itself from liability for anything other than intentional acts of its employees, even if those acts cause a great deal of harm, such as a failure to properly secure the voluminous and very important private data of practitioners, for example, or failure to properly screen or transmit adverse actions that are taken against a practitioner, allowing a practitioner to continue to practice and could cause significant harm to patients. In fact, they could rely on that failure of the commission to potentially to skirt or avoid individual state from even finding out about certain actions that would otherwise disqualify that practitioner. I was trying to find some kind of an analogy in terms of liability to use here. And so I looked into with the help of counsel for the committee and some others, what the standards of liability are in Minnesota, for example, for governmental action. And it sounds like the closest analogy we can find is a government entity for this. In Minnesota, the Tort Claims Act provides that the state is liable for employees acting in good faith and within the scope of their employment, as if a private person would be. So it doesn't have, the sort of intentional tort language. It doesn't have negligence language. It makes the entity liable for employee actions that were done in good faith. Presumably then an employee would be personally liable for acts that were not done in good faith, but were still within the scope of the employment. The standard for nonprofits is similar, but not too different. For the director of a board of nonprofits, if they discharge their duties in good faith and believe it to be in the best interests of the corporation and acted as an ordinarily prudent person in the same position, that's the standard for immunity for a board member of a nonprofit. And officers and members have slightly modified standards of immunity. Any one of those, it seems to me, would be a better approach to protecting the interests of Minnesotans, should they end up having a claim against the commission by action of the commission as a body or by action of individual employees or the executive director of the commission. So, I had an amendment teed up to insert negligence in this bill. Now, honestly, I'm not sure if the negligence standard would be the right way to go, but I think it's much better than the broad immunity that the bill currently uses to protect itself and its employees, particularly if the state that ends up being the choice of law has this vicarious official immunity doctrine, which we don't have an answer to. So I'm prepared to offer that amendment, but I see Senator Benson has a question.
Senator Benson.
Chair, I was looking at the Interstate Compact for Adult Offender Supervision currently in Minnesota statutes, and it doesn't have the negligence standard where Mr. Carlson had raised the concern about the negligence standard. It refers to willful wanton misconduct, but also in that statute, it allows a venue choice. It allows the commission a venue choice of the DC court or the federal court where the commission offices are located. So Minnesota's already made some decisions about the concerns that are being adjudicated. That doesn't mean this committee doesn't have purview for debate. And it doesn't mean I'm dismissive of concerns about venue. But we have already passed into law something that said DC or where the commission office is. And so that I want us to reframe the argument based on what we've already done in Minnesota. And if we want to fundamentally change, then we're going to have a lot more compacts that we're going to have to go through. And I just did a cursory review, again, not a full in-scope legal review for the benefit of this committee, but we have already decided that there is a limited jurisdiction allowed in compacts. And we have already decided that negligence standard is not the essential action for Minnesota to be in or out of a compact. And so I'm not trying to be dismissive. I'm just asking if it has never been, no, if it hasn't been significant enough to stop legislative action. The Adult Offender Compact was amended in 2014. As recently as 2014, a compact with limited jurisdiction and no negligence standard came before judiciary review. And so if I could help reframe the argument to what is essential, are we going to pass this compact and join it, or are we going to materially amend it?
Senator Latz.
Well, Mr. Chairman, I have a great deal of respect for Senator Benson and the research that she's done and the preparation she's done for this bill. But I personally do not feel bound by what, past legislative oversights may have been. If the issue wasn't flagged or engaged for discussion in the committee, we don't even know, frankly, if that was a conscious decision with regard to that, the adult offender compact or not. I don't have a particular recollection of that discussion as it went through the process.
And Mr. Chair.
Senator Benson.
Senator Latz, I think you were chair of judiciary at the time.
Mr. Chairman.
Senator Latz.
That is correct. And if I didn't catch it, no one else caught it at the time, or if it wasn't as great a concern at the time to be recognized, then that's on us. But that doesn't mean that we can't recognize issues now that need to be addressed.
Thank you, Mr. Chair. And I certainly respect Senator Latz's right to continue to make his case for amending this bill. And so I will step back. But thank you, Senator Latz, for letting me raise a point.
Senator Latz, are you going to offer an amendment or decline at this time?
Well, I'm going to offer an amendment, Mr. Chairman. I would just say we have so many of the bills that go through our legislature every year are fixes or repairs to past statutes that we've done. That I'm sure every one of us senators on this call here have carried more than one of those bills. So I don't think we should let that impede our ability to make better law this time. So, Mr. Chairman, I would like to offer the A3 amendment.
Senator Latz moves the A3 amendment. Members, these were emailed to you ahead of the committee, and they're also posted publicly on the committee page, the hearing page for today's committee on the Senate website. So if you don't have a copy of the A3, please let us know right now. We can get that to you. But Senator Latz to the A3 amendment.
Mr. Chairman, thank you. This amendment inserts the standard of negligence into the three appropriate lines on page 20 of the bill so that individual employees and theoretically vicariously the commission itself could then be held liable for a negligent misconduct, if you will, and not only intentional misconduct that caused harm to Minnesota residents or citizens. If I think maybe we could still use some more work on this provision. Frankly, I think it might make more sense not to try to fix this today, but only if we intend to give ourselves some time maybe to look even further into the standards of making something comparable to government immunity that we have in Minnesota apply here. But I don't see how we can draft that on the fly, frankly. So I at least want to get an attempt to put the negligence standard in there. So I offer the A3 amendment.
Discussion to the A3 amendment, Senator Benson.
Thank you, Mr. Chair. And again, this would be a material amendment, which would stop the compact. The entire purpose of this bill is to be able to join a compact that would facilitate telepsychology. There's not a negligence standard in the Interstate Medical Licensure Compact enacted in 2015. There's not a negligence standard in the Interstate Compact for Educational Opportunity for Military Children enacted in 2014. And so, members, it is up to the committee if you would like to add a negligence standard to this bill, but I would say that would put the ability to enter this compact in peril, and it is not something that we have done in other compacts. Your judgment is not bound by previous legislatures, but I would ask you to weigh this amendment versus the good that would come out of telepsychology.
So
to the A3 amendment, Senator Latz.
Thank you. Look, I don't want to be the one that stands in the way of good law. On the other hand, to say that this is a good law other than the provisions we're dealing with, therefore we should accept the bad provisions just so we can get the good provisions passed, is really not a very good way to make legislation. That can be used about any bill that comes before us that we, especially in the judiciary and civil law committees, where we look at the language very carefully, and we decide if those particular provisions are important and need to be repaired before they move on and become part of a larger package. In fact, we see that all the time on re-referrals, this just being one of them. So I would really resist the argument that we shouldn't do our job because we like the bigger bill and therefore we're going to let it go anyway. I don't think that's a good principle upon which to make any decision, let alone something like this where the consequences of harm from a data breach or other kinds of adverse action that goes unprocessed, undisclosed, are very serious, and the harm no less important because it's, psychological or psychiatric harm than if it were some other kind of harm. So I'd ask the members of the committee here to make a judgment based upon the merits of this particular provision, and let's see where that falls.
Any more discussion to the A3 amendment? Senators Anderson and Westrom had your hands up and then down. Do either of you have comments to the A3 amendment?
Chair, no, not to the A3 amendment.
All right. Thank you, Senator Latz, for bringing this amendment forward. I have weighed out the standards as we've debated them all week here for 2 committee hearings, and I have decided to go ahead and support the compact in its original form as Senator Benson is pushing. I understand you're welcome to have a different opinion on that, but that is after the judgment and weighing out of these values, hearing the testimony today that has described what has actually taken place and what have been possible situations that have never been dealt with before. We can consider many analogies with that, but I am comfortable with the compact language as it is written, and I would oppose the A3 amendment. Mr. Sands, you raised your hand. You wish to speak briefly to the A3 amendment?
I do, Mr. Chair, thank you. I just wanted to provide some context for the committee members about this, like the totality of client claimants that would be potentially making these types of claims that would potentially make the commission a party to a lawsuit. And we track this data at the Board of Psychology. Practitioners have to provide an update when they do a renewal, letting us know if they've been a participant in a malpractice lawsuit. And I can tell you that over the past 5 years, we've had roughly 20 malpractice reports from practitioners over 5 years. And I would say roughly half of those are individual practitioners, and roughly half of those are people that work for the Department of Corrections or the Department of Minnesota Sexual Offender Program. And so I just wanted to give a scope, a sense of how many people we're talking about that would be making claims or against psychologists over the last 5 years. I thought the committee might think that information is relevant.
Any final discussion to the A3 amendment, or we'll proceed to a vote?
Mr. Chairman.
Mr. Carlson.
Thank you, Mr. Chairman and members. Briefly, I really appreciate the testimony of Mr. Wolfberg. I thought that was very enlightening, but I think he was very clear that it's the commission itself that would make a determination if it's material. And I would point out that I disagree with Senator Benson that the medical licensing compact is not based on a negligence standard. If you look at 147.38 on Article 14, their liability is limited as a municipal employee or a state employee, and they only lose that protection, which is a negligence-based standard, and they only lose that protection if their actions are intentional, willful, or wanton. And I'll give a brief shout out to Senator Latz that Adult Supervision Pact was adopted before he was a member in 2002. And the change that came before you in 2014 just removed a couple facilities that were in Red Wing and others that were included. So you didn't miss one, Senator Latz. I just wanted you to know.
Good to know.
So anyway, I think that medical licensing compact, which doesn't have a venue provision and is based on negligence, has better language, and I think that would be a better guide for us. Putting negligence in helps, but there could be another way to write it as well. Thank you.
Members, please turn your cameras on for the vote and unmute yourselves. All those in favor of adopting the A3 amendment signify by saying aye.
Aye.
All opposed say no.
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 The motion does not prevail and the amendment is not adopted. Any further discussion to the bill?
Mr. Chairman,
Senator Latz.
I would like the committee to consider adopting the A2 amendment.
Senator Latz offers the A2 amendment. Again, members, this was emailed out to you earlier and it's posted on the hearing page to the A2 amendment. Senator Latz.
Thank you, Mr. Chairman. This amendment deals with the venue for claim against the commission. We had conversation on Tuesday about alternative language that would give Minnesota residents an option other than having a case venued in U.S. District Court in Georgia, which is inherently inconvenient and more expensive for a Minnesota resident should they have a claim against the commission. On the advice of committee counsel, the way this amendment is phrased is that their alternative venue would be where the plaintiff resides, since rather than the location of the harm, since if, say, there were a data breach and the commission had failed to properly secure its data, or if there were staff at the commission that were inappropriately that had not been properly trained and were inappropriately accessing data that they didn't need to use for their particular task, then the harm would still occur in Georgia, but that wouldn't help the Minnesota plaintiff find a venue that's more convenient in order to bring a claim. Convenient in the sense of less expensive, wouldn't require the same level of travel for them or for their counsel were they to bring such a claim. So this language has where the plaintiff resides. Remember, members, we are a sovereign state. We have a choice of whether we want to give up sovereignty to an interstate compact commission, but we act on behalf of the health and welfare of our own residents. And it would not be to the advantage of our residents to have to bring a claim in federal court in Georgia if they are here and aggrieved with a claim against the commission. Now, it sounds like it's going to be exceedingly hard to establish a claim against the commission because this committee has seen fit not to adjust the standard of liability, but at least we ought to give them their day in court. If they think they got a valid claim and they can convince an attorney that they've got a valid claim, presumably most of these people probably would not proceed pro se, then they at least ought to have reasonable access to the judicial system in order to bring that claim. So that's the basis for this amendment.
To the A2 amendment, Senator Benson.
Thank you, Mr. Chair. Well, I don't think it is unreasonable that where the harm occurred should be a venue. I do think the risk of an individual Minnesotan having actions against them by the commission. Remember, this isn't about the licensed professional. Senator Latz isn't, this compact doesn't change jurisdiction for bad acts by a licensed professional. And I know bad acts is a specific legal term, but it doesn't impact a Minnesotan's relationship with a licensed professional who has a specific duty to them. It only has to do with the compact, which is voluntary for an individual licensee to join. The data of individual Minnesotans isn't shared beyond what is allowed by state law in public documents already. So this would be the licensed individual's information as they voluntarily join the compact. So not to be dismissive of the right to adjudicate in a location closer to the point of or where the harm occurred. Again, the likelihood of this sort of action being taken is small, to say the least. And again, I believe this would be a material change that would raise the bar for us getting into this compact.
Senator Westrom.
Thank you, Mr. Chair. Senator Benson, to your question there, if I'm understanding it right, the issue or the challenge would be not if a patient from southern Minnesota had a doctor from, I don't know if Iowa is one of the closest states in the compact or a close state to Minnesota. If there was an issue between those two, it's not venued in Georgia, but if it's an issue against the compact, that's when it would be venued in the issue. That's primarily what it's limited to, if I understand that right. Is that correct?
Senator Benson.
Mr. Chair, that is my understanding, but Mr. Wolfberg is here if you would like to correct any understanding. I would appreciate it. The individual would still be protected by Minnesota state law, and an individual practicing via telehealth or temporary in person would be responsible for knowing the laws of the state of Minnesota and following the laws of the state of Minnesota. This Senator Lott's amendment applies only to the commission.
Mr. Wolfberg, do you have a comment?
Not other than to agree with Senator Benson.
Senator Westrom.
And Mr. Chair, Mr. Wolford, maybe you'd know the answer, but what are the closest other states to Minnesota that's already in the compact? And a question I had earlier, and I held off asking it, but how many other states have not adopted the compact? We heard about Michigan. Apparently the legislature adopted it, but the governor chose not to. But are they the only state so far, or is there other states that haven't?
Mr. Wolfberg.
Two parts.
If the question is, has the legislation been vetoed in other states? I can't speak to that. I do not track that. I'm not certain. But I can tell you that there are 15 member states. So as of yet, 35 states have not adopted it. It is under active consideration by a few states right now in their current sessions, but I do not yet know the outcome, similar to what's happening here in Minnesota.
And Senator Westrom, we also are on the A2 amendment at this time, but Senator Westrom.
Correct. And Mr. Chair, just the second part of the question, what is the closest state we have to Minnesota in the compact already?
Mr. Wolfberg.
Yeah.
If you know.
Yeah, I'm looking at the list of states and then wishing I paid better attention in geography class in middle school. But probably Illinois, Colorado, those would probably be geographically the closest ones. Iowa is not yet a member.
So use Illinois for all your future examples. Apparently, Senator Westrom is the answer to your question.
Well, and that's where I'm going, Mr. Chair.
Senator Westrom. Senator Westrom, we may have lost you with your connection at this point.
Oh, can you hear me?
Oh, now you're back on. You should repeat anything you just said.
I'm going to shut my video off. Mr. Wolford, just a quick question to clarify the first question I had. But essentially, if a customer in Rochester, Minnesota, southeast Minnesota, had a doctor from Illinois that was performing in Minnesota through this compact, but there was a negligence or a malpractice by that doctor in Illinois, my understanding is that action would not be subject to this venue in Georgia. To clarify my first question, is that accurate?
Mr. Wolfberg.
Senator, that is accurate. That type of case would not be subject to the venue provisions in the compact.
Senator Westrom.
Very, very good. That's it for now, Mr. Chair.
Any further discussion to the amendment? Senator Latz.
Thank you, Mr. Chairman. Just to clarify for the record here, the medical compact does not have any jurisdictional venue provisions relating to claims brought against the commission. It does have jurisdictional provisions were the commission to take some sort of enforcement action against member states. For that, they have the choice of the U.S. District Court in the D.C. District of Columbia, or in the state where they are located, where their principal place of business is located. But there is nothing that says claims where claims should be venued if an individual is bringing a claim against the commission. On the other hand, the provision that we're looking at today here on line 14.16 says venue and is proper and judicial proceedings by or against the commission brought solely and exclusively where the principal office of the commission is located, which is to say, at least for now, Georgia. So I just want to make sure if we're going to follow the precedent set by the medical compact, then we should remove the venue provision altogether from this bill before us. I'm not proposing to do that, although we should just maybe do what Senator Benson suggested earlier and just adopt the comparable provisions from the medical compact. But if we're not going to do that, we should at least give access to the Minnesota Federal District Court for Minnesota plaintiffs.
Any further discussion to the A2 amendment? Seeing none, members, please turn your video cameras on and unmute.
Mr. Chair.
Senator Westrom.
Mr. Chair, just to Senator Latz's point, it does seem like it'd be very limited for actions going against the commission or the compact, a commission. Much more likely that it's going to be between a patient and the provider in most cases. But just to give the committee additional perspective, and it's not probably what you like if you're not somebody that lives in that venue, but this does happen often this past summer and fall as different parties have looked at and some of us legislators have looked into actions against the governor for his overreach or abuse of the emergency power statutes. Ironically, if you live in Roseau, Minnesota, you kind of get treated the same way because all those actions similarly have to be filed in Ramsey County, which happens to be where St. Paul and those state agencies are. So there is an analogous precedent that you'll see in other areas, right or wrong, that establish that the venue is where the agencies or the potential aggrieving party is located. And so that's under current Minnesota law as well. And that's okay if you live in Minneapolis or St. Paul, but if you live in Laverne or Roseau, you're stuck going a long ways for venue, which is what this issue is kind of about. But I think it'd be quite limited for actions against the council actually, as we look at this.
All right, members, turn your video cameras on and unmute for the vote. All those in favor of adopting the A2 amendment signify by saying aye.
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 Opposed, say no. No.
Oh.
Oh,
The motion does not prevail and the amendment is not adopted.
Division.
Senator Latz has called for a division. Please, if you're in favor of the A2 amendment, please raise your hand and keep it up while we make a count. All right, thank you. Please lower your hands. All those opposed to the A2 amendment, please raise your hand and leave them up while we make a count. All right, on 3 votes to 5 votes, the motion does not prevail and the amendment is not adopted. Any more discussion to Senate File 193? Senator Limmer.
No, Mr. Chairman,
okay.
I had a hand up by mistake.
Senator Latz, your hand has stayed up this whole time, so I don't know if you're asking for new opinions or not in the debate.
Mr. Chairman, I didn't realize it was our responsibility to go lower our hand on the Zoom screen. So I apologize for that, but I did have a thought to offer with regard to the purpose provision.
Senator Latz.
Mr. Chairman, I can't recall any instance in my years on the Judiciary Committee when it included the Civil Law Committee, when on a bipartisan basis, we did not find it within our jurisdiction as a committee to delete purpose clauses. And so I was a little bit surprised to hear Senator Bingham say that it is a clear statement by the chair that Article 1 is not within the jurisdiction of the Civil Law Committee. If not this committee, then I don't know which committee would have the most relevant jurisdiction for purposes of ensuring the integrity and proper drafting of the legislation. But I think, and we've already, the arguments that have been brought forth by Senator Westrom and by Mr. Wolfberg that these provisions are hardly ever going to get used tells me they're not material. So why do we even care if we amend them? Yet we still have 5 to 3 votes against amending them. So on the theory that it's going to cost the state the ability to get into the compact, obviously 2 internally inconsistent positions to hold at the same time, Mr. Chairman, and I'd really find it hard to believe that the purpose provisions, would be material to whether or not we get in to the compact. I'm not going to fall on my sword over the purpose provisions if it becomes the will of the legislature to start putting purpose provisions into these bills. Well, not only does it become, frankly, a crutch for lazy drafting, because you can always figure, well, the courts will just fall back on the purpose because if they can't figure out what was supposed to have been intended in the drafting of the bill. But also, we're going to see a lot more purpose statutes come along. And we've already dealt with that once, where we have purpose provisions have already come through this committee, in fact, which was more like it was a pretty bold policy and political statement in the purpose provision. And to Senator Limmer's credit, he agreed that it should not be included in his bill that went forward from the committee and it was removed. I would say the same principle should apply here. But I'm not going to offer an amendment. I just want to make my statement for the record. It's pretty dangerous precedent if we start letting, just like we're going to have bills coming through that have names given to them, which, Joe's Law or whoever's law, I think Senator Senjum has a bill coming forward with a name attached to it. And we pretty routinely remove those names with all due respect to the people after whom those bills are named. But if we're going to start setting new precedents, then everyone's going to scramble to make sure their bill has a name on it, for purposes other than amending the statute to achieve their intended purpose. So there, I'll get off my high horse now, Mr. Chairman, and I'll leave it at that.
Well, and Senator Latz, it is hard to differentiate because all our committees are identical now from our same seats and our same Zoom screens and all of that, rather than differing committee rooms and setups and structures. But I do think the bill you are referring to was a Judiciary Committee bill and not a civil law bill. I don't believe that has come through this committee here, but that's my recollection versus yours for that purpose. Senator Bingham.
Thank you. And I couldn't agree more with Senator Latz. But my point when I meant earlier, just to Senator Latz, was when Senator Benson brought this bill to us earlier this week, she very clearly laid out the articles that were under this committee's jurisdiction and had stated that the first article was not under this jurisdiction. I think it would probably maybe be a state government finance thing, or maybe your state government and elections committee one. I'm not quite sure, but that was my rationale for making that mention, that both the chair and Senator Benson went over the jurisdiction of the articles in this bill. So that's why I said that.
Senator Limmer.
Thank you, Mr. Chairman. I had a question. There was a reference to how many states have supported this law. Is it correct that 15 states have adopted this?
Mr.
Let's
Wolfberg,
compact.
I believe you had that info before.
Yes, Mr. Chairman, it is 15.
And is
Senator
all of,
Limmer.
and in comparison to every state, is the language identical?
Mr. Wolfberg.
For the most part, it is, but I can't say that every word is.
Is it
Senator Limmer.
substantive? Is it substantively identical?
Mr. Wolfberg.
I cannot say that it is.
Senator Limmer.
Now, I read a letter this morning coming from a law office in support of this legislation that said, if, and I can't remember the exact words, but it basically said if this version of the bill is not passed in the state of Minnesota, it would negate the benefits of the compact and its relationship with Minnesota. So how does that jive with a potential state that has passed perhaps a very similar but different version of this bill elsewhere in the country?
Mr. Wolfberg.
I can say that there have been instances in which amendments were passed in states that passed legislation prior to the commission coming into existence. The best answer I can give is that because the commission didn't exist, there was no real formal process by which those could be looked at. And I will say that this process in Minnesota has brought some of those inconsistencies to light. And I think the commission intends to deal with those. And I've been told that one of the states is already jumping on it in their current session. I think it was one word. And I think that they are in the process of amending that in their current session. So I know of two where there are variances from the compact language. And I think this process in Minnesota has brought that into specific focus. And I think that because those bills were passed before there was a commission, because it needed 7 states for the commission to come into existence, I think that is, then the commission had to get rolling and had to start the process and get the interstate privilege moving. I just don't think that was looked at or focused on, but it is now. And I think those are being addressed.
The other
Senator
question I
Limmer.
had, Mr. Chairman, is there was a reference to benefits of the compact relationship. Is that a package of the word benefits is a little confusing to me. Could you tell me what the benefits are, or is there a list that would tell me what those benefits are? What does the citizens of Minnesota get out of joining the compact?
Mr. Wolfberg or Senator Benson, which of you would like to take that? Senator
Mr.
Benson.
Chair, Mr. Sands might be able to best explain, because it's about access to the profession across state lines.
This was some of what we covered on Tuesday. Mr. Sands, if you could recap for us.
Right. I'll just do a very brief, Mr. Chair. Thank you. I'll do a very brief recap. What the benefits of entering into the compact would be that it increases provider access to Minnesotans, including military that are moving around the country, perhaps. It would allow for increased access for our college students who are going to other states that are part of the compact. It also provides a national standard for vetting and approving competent psychologists to practice into Minnesota. And it provides the board with regulatory tools to regulate these individuals as e-passport holders that are providing services into Minnesota on par with how we regulate licensees in the state.
Senator Limmer.
No, thank you. I'm done.
And members, just to remind you, we're still on our first bill of 3 bills on today's agenda, and we will be completing today's agenda today. So keep that in mind as we get bill number 1 completed here. Any more discussion to Senate File 193? All right, seeing none, any final comments from Senator Benson?
Mr. Chair, thank you to the committee for this very intense work. With telemedicine advancing, I think we are going to see more interstate compacts for people practicing across state lines. And so perhaps for the benefit of the committee, doing some work in the interim to give some guidance so that people like Mr. Wolfberg would have direct engagement with what Minnesota expects. I do think that this conversation was informative and helpful.
Thank you, Senator Benson. If members would turn their cameras on and audio on for a vote. Senator Anderson, would you be willing to give the motion for Senate File 193 to be recommended to pass and placed on general orders?
Chair, I move that Senate File 193 be recommended to pass and be placed on general orders.
Thank you, Senator Anderson. Members, with your video on, all those in favor of adopting Senate File 193, please signify by saying aye.
Aye.
Aye. All
Aye.
opposed, say no.
No.
The motion prevails and the bill is passed. Thank you, Senator Benson.
Thank you, Mr. Chair and committee.
All right, is Senator Duckworth on the screen? There you are. Our second bill is Senate File 529, a bill from Senator Duckworth. Welcome to the committee, Senator Duckworth.
Hello, Mr. Chair. Thank you.
Please feel free to begin the explanation on your bill.
Very good. Before we begin explaining the bill, I do have an author's amendment. A1, it basically provides a definition for the word disability as it pertains to the bill.
Thank you for that. Senator Johnson, would you be willing to move the A1 author's amendment?
So moved.
Thank you. Senator Johnson moves the A1 author's amendment. All in favor of adopting the amendment signify by saying aye.
Aye.
Aye. Opposed, say no. The motion prevails and the amendment is adopted. Senator Duckworth, your bill's in order.
Very good. Thank you, Mr. Chair. Thank you, Senator Johnson. Appreciate that. Just a quick overview regarding Senate File 529. This bill permits a landlord to require supporting documentation when a tenant requests a reasonable accommodation for their service or support animal and prohibits a tenant from misrepresenting their need for a service or support animal. This bill really aims at protecting all those involved, whether it be the tenant or the owner of the property. And I just want to acknowledge that a lot of work has been done on this bill previously. It's my understanding that several stakeholders have been engaged, have reached agreement in regards to the bill, and it just for some reason didn't make it through last session when the pandemic occurred. So with that being said, Mr. Chair, I do have some folks that are here to testify and speak to the bill. And if you would permit it, I would love to start with Mr. Elwood.
Sounds good. Senator Duckworth, thank you. We have 2 testifiers for the bill. First up, Mr. Elwood, welcome to the committee, and please state your name for the record and proceed.
Thank you, Mr. Chair. Members, my name is Ron Elwood. I'm the supervising attorney at the Legal Services Advocacy Project. I'd like to thank Senator Duckworth for bringing this bill, and I'm here today to testify in support of Senate File 529. Don't kick me out, please. I also really want to thank Ms. Stefaniak, who I'm assuming will be testifying after this, and the Minnesota Multi-Housing Association for inviting me and Legal Aid into this collaborative process of working through the issues on this bill and the language of the bill. I believe that this bill strikes the perfect balance of ensuring that documentation for requests for reasonable accommodations for service and emotional support animals is legitimate, while at the same time preserving and protecting the legal rights of Minnesotans with disabilities. So with that, Mr. Chair, again, I'm testifying in support. Thank Senator Duckworth, and I'm happy to answer any questions.
Thank you, Mr. Elwood. And thankfully, with all the buttons we have on our Zoom screens these days, the open trapdoor button is not one of them. So you're good in that respect. Our second testifier is Miss Leanna Stefaniak. I hope I pronounced that correctly. Welcome to our committee. Please identify yourself and proceed.
Mr. Chair, members of the committee, my name is Leanna Stefaniak, and I'm with At Home Apartments, which is a real estate company that operates in St. Paul. I serve as their general counsel and am in charge of overseeing reasonable accommodation requests that come through our office in connection to service and emotional support animals. I echo many of the comments that Mr. Elwood has stated, and also state my support for this bill because it provides a clarity for both the tenant and a landlord on how to operate in this space and what's an appropriate documentation and request for both for the tenant and for the landlord when it comes to making reasonable accommodation requests. There's a boutique industry that's out there just kind of selling letters and certifications online. And that's harmful not only to those who truly do have a disability and need these additional supports, but it's harmful for the property owners as well. So I do think this proposed bill does strike that balance and protects everybody who has a vested interest in it.
Thank you, Ms. Stefaniak. Members, are there any questions from the committee to either the testifiers or to the chief author? Senator Johnson.
Thank you, Mr. Chair, and Ms. Stefaniak. Just had a quick question. You mentioned that there's a cottage industry that just cranks out paperwork regarding this. When you are putting together your supporting documentation, would those documents that you can get online, would that support the requirement for that documentation? The very thing that this is trying to prevent?
Ms. Stefaniak.
Thank you, Mr. Chair and Senator Johnson. Yes, so with these cottage industries, it's literally a click here, pay for this letter. And, sometimes it's a 2-for-1. Get this letter for your housing provider and this one for your airline. We're not trying to interrupt telemedicine or any kind of remote relationship that may exist between a patient and a doctor. In this instance, what we're trying to do is provide clarity on who can be issuing these letters and where they're coming from. So licensed practitioners who are, participating in telemedicine, for instance, those letters would be permitted. If a resident were to have just moved to Minnesota and still have a relationship with their treating physician in another state, we would permit those letters. It's really trying to get at the letters that come from websites, for instance, called waggy.com or certipet.com. The names of those websites in and of themselves are questionable. And so we're trying to help both tenant and landlord navigate that process with this bill.
Senator Johnson. All right, thank you. Any further discussion from the committee? Seeing none.
Mr. Chair.
Senator Westrom.
Mr. Chair, I just would speak in support of this bill and thank Senator Duckworth for bringing this forward and the proponents. I think it's unfortunate that there's an industry that tries to cheapen or diminish the benefit that disability dogs or truly service dogs bring to so many that really need them. And so I think tightening this up will benefit everybody, and including those that really need to have a service dog for an intended purpose and not just a pet and an excuse. I've heard this from others, property owners and business owners, but from a disability side of things, we need to also look at it as not ruining something that the blind and deaf and hard of hearing folks years ago lobbied very hard to get service dogs to be an accepted accommodation where needed on a individual, but a limited basis, in the sense that it wasn't going to have dogs running all over the place, but where they're needed and have a purpose, specific, significant service to provide. We recognize that business owners, property owners, neighbors have to put up with otherwise what is sometimes an inconvenience. And pets go to the bathroom, pets bark, pets growl and do other things unpleasant. And most of the time, people with service dogs, through leader dogs for the blind or deaf and hard of hearing, they do a very good job of taking care of their dogs, and they're not a pet. In fact, if you look at dogs that have service duties, I know in the blind community, most dogs that are working will actually have a tag on them: "Don't pet me, I'm working." That's because that's what they're doing, is working, and they're really providing a service. And so this, I think, will help clean up that gray area, or that ambiguity that some are choosing to cheapen or take advantage of. And so, Senator Duckworth, I think you're on the right track here.
Thank you, Senator Westrom. Senator Latz, and then Senator Anderson. Senator Latz.
Thank you, Mr. Chairman. I strongly support the bill. I think it's a great policy, and it's a shame we couldn't get it done last year. It's glad to see it come back through now. I just have one comment, I guess, not related to the substance of the bill itself, but this is the second or third non-controversial bill that I've seen come through the system where all of the authors are Republicans. And it just seems to me that in the past, sort of the practice had been, when there were consensus bills that were understandably introduced by Republicans because they're in the majority, that there was an effort to make it bipartisan by seeking out some Democrat senators to co-author the bills.
Mr. Chair, if I may, I think I've already addressed Senator Latz's point here. I don't want to have him go down a trail he doesn't have to.
Well, Senator Latz.
Well, I'd like to hear what Senator Duckworth has to say, but there's even a spot available on the bill here. I didn't see, unless I missed it, I don't see a Democrat on the bill. We've had some bills come through the Judiciary Committee, similar situation. I recall at least 3 in the same situation. I just would encourage members of the majority, at least where we have consensus, to stick with sort of our common practice of making bipartisanship possible, where we have a bill that we can all agree on without any controversy.
Senator Duckworth.
So I'm new, but I'm a quick learner, and I'll heed your advice. You'll be happy to hear that the revisor's office has already been contacted, as Senator Rest has agreed to co-author this bill, and that's already been confirmed. So thank you, sir. I could not agree more.
Thank you.
Thank you, Senator Latz. Senator Anderson.
Thank you, Mr. Chair. Senator Duckworth, what are the consequences if a entity misuses claiming a service dog as being trainable and viable for a disabled person? What are the consequences? Is there anything in the bill?
Senator Duckworth.
Mr. Chair, Senator Anderson, thank you for the question. This bill does not address if an entity were to be kind of manufacturing documentation regarding service animals or companion animals that may be suspect. This bill is really limited in scope to a landlord being able to request documentation from a licensed professional as pertains to somebody needing that service animal or companion animal.
Senator Anderson.
That's great. I just was wondering if we have, if there's going to be a follow-up bill to put in place to address the need to take care of these people who want to misrepresent themselves and providing these animals to our people out there.
Thank you. So Senator Duckworth, would it be fair to say then that the bill aims for if a tenant is, if the landlord is negotiating a potential new lease with the tenant, this documentation from a licensed professional is listed here, could be a requirement that he would need as a part of that application process and could be used to base his decision on? Is that a fair characterization?
That is correct, Mr. Chair.
Thank you, Senator Duckworth. Senator Westrom.
Mr. Chair, Senator Latz, I'd take your comments as strong support that the Senate needs to update its rules like the House did. Might have been about when you were in the House as well, where they allowed more than 5 authors. Some bills just fill up pretty fast, and I've been a proponent that the Senate could do the same thing the House adopted about going on 20 years ago now, that they allow up to 35 authors on a bill, and we don't need to make that step, but let's look at adding 10 or 15 authors on a Senate bill, and we'd have a lot less bills introduced then too if we lifted the cap. So I take your comments as strong support for us looking at the rule, and I wouldn't want to pass up the chance to make that pitch, because I've advocated that for several years.
Well,
Thanks for your comments.
Since it's not to the bill, Senator Westrom, it's not technically in order, but Senator Latz, brief comment.
Mr. Chairman, I'm certainly open to looking at that, but I've also heard that sort of the word is just kind of sent out, by Senator Chief Author. Hey, I've got a bill at my desk. First 4 people to come along to co-author, get it, rather than making a conscious effort to find bipartisan co-authorship. And I think really the responsibility should be on the Chief Author to reach out to bipartisan co-authors where it's appropriate. We got a lot of conflict in this legislature for a lot of reasons right now anyway, but where we can find some comedy, COMITY, I suppose, as well as COMEDY at appropriate times, I think we should reach for it.
Any further discussion to Senate File 529 as amended? Seeing none, any final comments, Senator Duckworth?
No, sir, Mr. Chair, other than thank you and to the members of the committee for your time this afternoon. I greatly appreciate it.
All right, thank you. Senator Johnson, if you would give the motion to Senate File 529 as amended be recommended to pass and sent to general orders.
So moved.
Thank you, Senator Johnson. Members, if you turn your cameras on, all those in favor of adopting the bill as amended signify by saying aye.
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 Opposed, say no. The motion prevails and the bill is passed. Thank you, Senator Duckworth.
Thank you, Mr. Chair.
Our final bill today is Senate File 395 from Senator Johnson.
All right, thank you. I see that we're already 2 minutes past our time. So, Mr. Chair, we'll be able to continue this past our allotted time.
Yes, Senator Johnson, I am going to flex the committee time a little bit so that we can get these cleared off our agenda.
All right, thank you very much. Appreciate that. So Senate File 395 deals with uniform recognition and enforcement of Canadian orders for protection. Now, for some reason this year, I've gotten 2 bills related to Canadian law, and I just want to inform the committee that I am not Canadian, as the rumor has it. I have eaten at Tim Hortons twice, but that was more by necessity than anything. But this is one that I think is really important for, especially, if you look at the authors on here, we have Senator Bach and Senator Utke and Eichhorn. And even you, Mr. Chair, but for us Northern folks, we have a lot prior to COVID regarding I see Senator Latz is looking for, there was bipartisanship there. We had Senator Bach,
Look
so.
at our Democrats, Senator Johnson.
Yeah, that's not
Doesn't count
bipartisan.
anymore as a Democrat.
Doesn't former Democrat work anymore or not?
I think he's caucusing with you guys. He's got one of your chairs.
All right, well, we'll
Senator
improve
Johnson.
on that. So anyways, so what we have is prior to COVID, a lot of interaction between Northern Minnesota residents and Southern Canadian residents. And oftentimes, a lot of our legal jurisdiction ends up colliding too. I think this is a very straightforward bill that really makes sense for our OFPs, orders for protections in civil matters, really protecting those who are in terrible situations in their domestic lives. I've got a couple of folks with me here today that are very well versed in this and have some stories and examples that would really give some clarity to why this bill is necessary. So, Mr. Chair, I'd ask that at this point that be turned over to the testifiers.
Thank you, Senator Johnson. The first testifier on my list is Ms. Michelle Timmons. Welcome to the committee. Please identify yourself for the record and proceed.
Yes, thank you, Mr. Chair and members. I'm Michelle Timmons. I'm a uniform law commissioner from Minnesota. I'm now, I guess, I've been doing that for about 22 plus years, and a former reviser of statutes for the state of Minnesota. So yes, as Senator Johnson said, this is a pretty straightforward, short act. And another one like the one you just discussed that we started last year, but was stopped because everything needed to shut down due to COVID. It's really a collaboration between the Uniform Law Commission in the United States and the Uniform Law Conference of Canada. It was worked out during the time that Judge and Commissioner Harriet Lansing was president of the ULC, and she'll be adding a few comments after mine. So the Canadian provinces close to us, including Manitoba, Saskatchewan, British Columbia, and Quebec, already recognize and enforce Minnesota orders for protection. So what this act would do is really give reciprocity to Canadian orders. And we think it has the potential to reduce violence in Minnesota with minimal cost. And it may also, if the pandemic ends here, may aid in business travel and promote tourism. As Senator Johnson noted, Minnesota is one of the most often visited states by Canadians. And so to answer some of the anticipated questions from senators such as Senator Limmer and Senator Westrom, after being approved by the ULC in 2015, this act has been enacted in 6 states, including 2 that are very close to us, border us, North Dakota and Wisconsin. In addition, Washington State, California, Nevada, and Delaware have enacted these provisions. And I think it might have been more because there were several introductions last year that, just as in Minnesota, were stopped because of the COVID pandemic. So we don't know of any opposition. There is a lot of support. Violence-Free Minnesota is in support, and Katie Kramer expresses her regrets. She had wanted to testify and was not able to work out a conflict. Global Rights for Women is also supportive. Cheryl Thomas is here and will be testifying in a few minutes. We also have support from the Minnesota County Attorneys Association and the Minnesota Court Administrator's Office. Janet Marshall told me that because the adding the Canadian protection orders, which is permissive, she thinks would be a relatively rare occurrence, that it would be something that could be absorbed by the courts with no problem. So with that sort of synopsis, I guess if the chair would like to call on Commissioner Lansing for some additional comments.
Thank you for your testimony, Ms. Timmons. Yes, Ms. Lansing, Commissioner Lansing is next on my list of testifiers. Welcome to the committee, Commissioner. Please identify yourself for the record and proceed.
Thank you, Mr. Chair. I'm Harriet Lansing. I'm also a Uniform Law Commissioner from Minnesota, and I am a retired judge of the Minnesota Court of Appeals. I will be brief, realizing that your time is short, and I know that I will be interested in hearing from Cheryl Thomas, who deals with this material on a daily basis. So what I want to say is that as Michelle has said, this was developed in conjunction with the Uniform Law Commission of Canada. We've worked very positively with them through the years, for actually more than 100 years. The Uniform Law Commission of the United States was very active in helping them create their own commission 100 years ago. So we have continued the close working relationship, and there are a fair number of bills that we'll continue to bring before you, and we're very happy to have some of them authored by Senator Johnson and other people who are listed. The Uniform Law Commission has also been active in drafting bills that provide protection for family support, other protection. In 2002, we drafted the Uniform Interstate Enforcement of Domestic Violence Acts for our domestic cross-border, or I should say interstate protections. And I was particularly pleased to see a day or so ago that there was a short article in the International Falls Journal that spoke favorably about this recognition of and enforcement of Canadian Domestic Violence Protection Act. And I think it's especially important in border states. And so I hope that you too will look favorably upon this, and I will defer to Cheryl, and happy to answer any questions at the end that you might have.
Thank you for your testimony. And yes, the final testifier is Ms. Cheryl Thompson. Welcome to our committee, and please identify yourself for the record and proceed. Ms. Thomas, your audio is not coming through. Still nothing coming through. I'm sorry. You could try logging off the meeting and logging back on and seeing if a refresh would help. I don't know if any of our staff have any other tips to share. I can try to hold on for a minute as we try to rectify this. Senator Johnson, do you have any final comment? Or maybe we could go to any questions from the committee for a minute while we're waiting for Ms. Thomas to get back on. Oh, she's back already. Try your audio again, Ms. Thomas.
Does this work?
Now you're coming through. Excellent. Ms. Thomas, welcome to the committee.
Thank you so much. Thank you, Mr. Chair, and thank you, Judge Lansing, and all the committee members. I'm grateful to be here and talk about the Canadian bill. My name is Cheryl Thomas, and I am the Executive Director of Global Rights for Women, and we are located in Minneapolis, Minnesota. We are 7 years old now, and our mission is to work on legal and systemic reform on violence against women, both locally and internationally. So we do work around the world at the request of partners in every continent of the world when they are drafting new laws on violence against women and girls and then enforcing them. So my testimony will just give you a little bit of context about the urgent need for this kind of innovative policy making. The global pandemic of violence against women is deeply serious. It has been named as the human rights abuse of our time by many global leaders. And certainly now during COVID, as women and girls are more isolated in their homes, this danger has increased just dramatically all over the world. And where we're able to get statistics, which is actually fairly rare still globally, they have skyrocketed during this COVID period. What we do know is that the order for protection remedy everywhere we have worked has proven to be one of the most effective remedies for domestic violence victims that we have. Women use it when they often won't use the criminal justice system for many reasons, of course, and they are able to find protection from it. So we know about just the statistics now, the rate of violence against women. We do have more statistics about that kind of pre-COVID. And one really powerful statistic that I often refer to is the recent one from the United Nations Office of Drugs and Crime, which did a study on the global just persistence of domestic violence as a human rights violation. And they found in 2017 that 50,000 women died that year at the hands of their family members, mostly men and intimate partners. That is 137 women per day dying around the world due to domestic violence. So I just give you those statistics as some context for the need for this cross-border remedy for violence victims. And one more quick thing, and then I'll stop because I know you're over your time. But Minnesota, you may know, has been just a powerful leader globally in the effort to end violence against women, sexual violence, and domestic violence. We have strategies and laws, the Duluth model of coordinated community response, the power and control wheel have been replicated all over the world now, translated into dozens and dozens of languages. There are those not only in the United States, but all over the world that look to us for leadership and, like I say, innovative policy making to end this global pandemic. So again, I did provide the committee with a summary of my testimony, and there are some references in there you may be interested in, and I thank you for your attention.
Thank you for your testimony, Ms. Thomas. Are there any questions from the committee to our testifiers or Senator Johnson? Senator Anderson.
Thank you, Mr. Chair. To the testifiers, especially regarding the, I'm just amazed at the number of women that you've mentioned, Ms. Lansing, dying because of the hands of their partner or family member. Is there any evidence to show that we've been able to see a reduction? I mean, 50,000 seems like it's too many, but is there a higher number that you can relate to? Then, not that I want to be higher, but the fact is that this is tremendously a high number to begin with.
Mm-hmm. Is the question directed at or
whoever can answer that?
Ms. Thomas, would you like to?
Yeah. Go ahead.
Ms. Thomas, go ahead.
Okay. I hope I understand your question, but we do know that where there are laws in place and particularly efficient and coordinated justice system efforts, that there is a significant, at least the numbers often don't go down, because when you have legal remedies like this, women report. But we do know, unlike when there are not remedies available to them, and we do know that when there are order for protection remedies in place, that women do feel safer, and most often those order for protections are not violated.
Thank you.
Thank you, Senator Anderson. Any other questions from the committee? All right, seeing none. Senator Johnson, any final comments? Senator Johnson, now your audio is not coming through for some reason.
Can you hear me now?
Yes.
All right. So I just wanted to thank you for the time, Mr. Chair and members, to bring up this issue. As you can see, it has a high impact, hopefully a low occurrence, but a high impact when it does come into play. So thank you for the time for this.
Thank you, Senator Johnson. The joys of Zoom meetings these days. Senator Johnson, if you would please move your bill at Senate File 395 be recommended to pass and re-referred to the Judiciary Committee.
So moved.
Thank you, Senator Johnson. Members, please turn your cameras on for the vote. All those in favor of adopting Senate File 395, please signify by saying aye.
Aye.
Opposed, say no. The motion prevails and the bill is adopted and on its way to Judiciary. Thank you, members. That concludes our business for today. Thank you for the robust discussion. And seeing that we have no further business, we stand adjourned.